Good day, class. And now we will be discussing about extinguishment of obligations. So Article 1231 provides for the modes of extinguishing an obligation. So 6 ang naka-enumerate dyan. However, please remember that Article 1231 is not an exclusive list. Meaning, meron pang iba. Meron pang iba na modes of extinguishing an obligation na hindi kasama sa Article 1231. So, this ilan sa mga examples nun? Death of a party in case the obligation is a personal one, mutual desistance, arrival of resolutory period, compromise, impossibility of fulfillment, happening of a fortuitous event. So, case number 67 sa URA versus DBP. Ang issue lang dyan ay whether or not DBP failed to fulfill its obligation to S. Ruling ng Supreme Court, no, because of mutual desistance. So, i-discuss ng inyong classmate yung case na yan. Article 1232, it is about payment. So, in law, payment and performance are synonymous. So, paano ba natin masasabi na mayroong payment? Payment consists of delivery of money, giving of a thing other than money, doing of an act, or not doing of an act. The burden of proof of extinguishing an obligation lies with the obligor. Of course, it is the obligor who will benefit if the obligation will be extinguished. However, when the debtor introduces evidence that the obligation has been extinguished, the burden is shifted to the obligee. Article 1233 talks about requisites for valid payment or performance as regards the prestation. One is integrity and two is identity. Integrity refers to the completeness of the prestation. So as a general class, the prestation must be performed completely. Exceptions to the general rule, Articles 1234 and 1235. Identity, prestation due must be delivered or performed. Itong Article 1244, diniscuss na natin ito before. So the debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value or more valuable than that which is due. In obligations to do or not to do, an act of forbearance can't be substituted by another act of forbearance against the obligee's will. So kung ano ang pinag-usapan ng parties, yun dapat ang gawin. So pwede ba yung substitution? Pwede yun. Basta pumayag yung parties. Okay? Kailangan may consent ng bawat isa or there's a stipulation with the consent of creditor. Article 1234, pakibasa na lang yung holder provision, may requisites yan. There must be substantial performance, and that's a case-to-case basis. And obligor must be in good faith. Class, good faith is always presumed. Okay? Each one of us is presumed to act in good faith. Ang pangit naman nun kapag ang presumption sa atin ay hindi maganda yung ginagawa natin, di ba? So good faith is presumed. Question, is it a conclusive or disputable presumption? This is a disputable presumption, meaning if there is an evidence to the contrary, mababaliktad yung presumption na yun. Okay? So yun. Article 1235, ano naman yung requisites niya? Number one, si obligee or creditor knows that the performance is incomplete or irregular. And number two, knowing that kahit na alam niya na incomplete or irregular yung performance, he accepted without any protest or objection. So what do we mean by accept? To take as satisfactory or sufficient, to give assent or to agree to an incomplete or irregular performance. As Gona versus Hamandre, issue dito whether or not J defaulted on his payment of yearly rent. The answer is the ruling of the Supreme Court is no dahil nagkaroon ng waiver. Diba? May waiver kasi yung class. Article 1235 of the Civil Code provides that the obligation is deemed complied when the obligee accepts the performance, knowing its incompleteness or irregularity and without objection or protest to the same. Article 1236, kanino naman dapat magbayad? Kanino pwedeng tanggapin ni creditor yung bayad? Okay? Sino yung dapat nagbabayad? Ganun yun. Ito yung Article 1236. So, who must pay? Of course, the debtor. Number 2, anyone acting on the debtor's behalf. Or, so sino yung mga acting on debtor's behalf? Agent, legal representative, successors in interest, and assignees. Number 2, any person who has an interest in the obligation. Of course, guarantors, mortgagors, owners of mortgage property of pledge, diba? And number 3, a third person who has no interest in the obligation when there is a stipulation that he can make a payment. Okay? So, tatandaan nyo yung tatlo. Ano yung effect of payment by a third person who has no interest in the fulfillment of the obligation? Class, this one, walang stipulation. Okay? Walang stipulation. Letter A, ito yung if with the knowledge of the debtor, ito yung may stipulation. Third-party payer may demand reimbursement of full amount he has paid. Subrogation of rights. Kasi nag-consent si debtor na babayaran ng third person yung utang niya. And letter B, paano naman kanyari walang alam si debtor or against sa kanyang will? Of course, kailangan pa rin, may reimbursement pa rin. Kasi without reimbursement, that's an unjust enrichment. So third-party payer can only demand reimbursement insofar as the payment has been beneficial to the debtor. Ang difference din ito, kapag walang knowledge or against the will, there will be no subrogation of rights as provided by Article 1237. So ano ba yung subrogation and reimbursement? Subrogation, maliban sa may right ka for reimbursement, kasama doon yung all other rights which the creditor could have exercised pertaining to the credit, either against the debtor or against third persons, guarantors or possessors of mortgages. That's in Article 1303. Kapag naman reimbursement class, ito yung babayaran yung inabunuhan mo. Kumaga. Okay? So it's a bare right to be refunded. O yung Article 1238, ang sinasabi lang naman dito ay ano yung yung payment made by a third person who does not intend to be reimbursed, it is deemed a donation. At kapag sa donation class, debtor's consent is material. Bakit kailangan yung debtor's consent? Of course, class, lalo na sa ating mga Pinoy, ayaw natin ng utang na loob. Lalo na sa hindi natin gustong tao, di ba? So no one should be compelled to accept the generosity of another. If debtor did not consent, no donation. Debtor must pay the third person payer. Di ba? 1239. Kapag daw payment, kapag sa payment, kailangan yung taong magbabayad must have a free disposal of the thing due and capacity to alienate. Ano ba yung sinasabing free disposal of the thing due? The thing to be delivered must not be subject to any claim or lien or encumbrance of a third person. Capacity to alienate, the person is not incapacitated to enter into contracts and to make a disposition of the thing due. Ito yung exemption sa Article 1239. Diba? When a minor between 18 and 21 years of age who has entered into a contract without the consent of the parent or guardian voluntarily pays a sum of money or delivers a fungible thing in fulfillment of the obligation, there shall be no right to recover the same from the obligee who has spent or consumed it in good faith. So that's an exemption to the rule. Kanino naman dapat bayaran ang utang? Of course, sa person in whose favor the obligation has been constituted. So sino yon? The creditor or obligee. Successors in interest. Any person authorized to receive it. Ano mangyayari kapag nagbayad ka sa unauthorized person? It shall not be valid even though made in good faith. Tandaan nyo yan, ha? Pero may exemption sa rule na yan. So, if creditor is a minor, payment should be made to his legal representative. If this is not possible, the debtor may relieve himself from responsibility by the consignation in the court of the thing or sum due. Okay? General rule. Benefit to the creditor of payment made by the debtor to a third person is not presumed and must be proved. That's the general rule. What are the exceptions? Ayun yung nakalagay sa Article 1241. So, benefit to the creditor is presumed. And since it is presumed, it is already presumed, it need not be proven. So, ano yung mga cases na yun? Letter A, the third person acquires the creditor's rights. Diba? Subrogation yon. Letter B, if the creditor ratifies the payment to the third person, ratification. And letter C, estoppel. Estoppel yan. Article 1242, it contemplates possession of the credit itself and not merely of the document or instrument evidencing the credit. So, credit itself, class, ha? Hindi yung papel. Again, good faith is presumed. Payment made to the creditor by the debtor after the latter has been judicially ordered to retain the debt shall not be valid. This is self-explanatory, class. Diba? Sinabihan ka na huwag kang magbayad doon sa debtor. Or i-retain mo lang yung utang sa'yo. Binayad mo pa rin. Makulit ka. So, hindi valid payment yun. So, garnishment, ano ba yung garnishment? Garnishment, it is a proceeding for the purpose of subjecting a debtor's credit to the payment of his debt to another. For example, si A may utang kay B. Nasa court na yung kanilang complaint, yung kaso. Si A pala, may pautang naman siya kay C. So si B, na may pautang naman kay A, pwede niyang ipa-hold yung utang ni C kay A para at least pakuha niya. May makuha siya. Garnishment. Article 1246, ito pinag-usapan natin ito sa generic or indeterminate thing. Diba? If the quality and circumstances have not been stated, the creditor cannot demand a thing of superior quality, neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration. Class, for example, si A nagbebenta siya ng tapang kabayo. Meron siyang restaurant, tapang kabayo. Si B, nagbebenta naman siya ng horse meat. Di ba? Si A, hindi siya po pwedeng mag-demand kay B na ang gusto kong tapang kabayo yung ano. Gusto ko isusupply mo sa akin yung karne ng mga pangkarerang kabayo. Hindi po pwede yun. Ang mahal doon. Milyon-milyon yun, di ba? So, hindi po pwede yun. Si B naman, hindi po pwede mag-deliver kay A ng mga sakiting kabayo. Kasi, restaurant ang kanyang business eh. Eh kung magkalat pa ng sakit, di ba? So, the purpose of the obligation and other circumstances shall be taken into consideration. However, class, the benefit of this article may be waived by the creditor by accepting a thing of inferior quality and by the debtor by delivering a thing of superior quality. Wala tayong magagawa, class, kung trip nilang magbigay ng mas maganda o si creditor okay lang sa kanya na mas mababa yung quality, etc. Wala tayong magagawa doon kung gusto nila. That's not against public interest or any law, etc. Article 1247, sinasabi lang dito, extrajudicial expenses shall be for the account of the debtor unless it is otherwise stipulated. Meaning, kung may kontrata sila, yun naman nangyayari. Kung anong usapan nila. Bakit si debtor ang magbabayad ng extrajudicial expenses? Kasi class, si debtor ang magbe-benefit sa extinguishment of the obligation. Okay? However, sabi nga natin kanina, kapag merong stipulation, yung stipulation ang mag-govern. Article 1248, it contemplates obligation when there is only one creditor and one debtor. The creditor may accept, but he cannot be compelled to accept partial payment or for performance. Class, as a general rule, partial performance is no performance at all. Okay? So, hindi mo po pwedeng pilitin si creditor to accept partial payments. However, if there's a stipulation, pwede. At yun lang din, kapag tinanggap ni creditor yung partial payment, wala tayong magagawa. Gusto niya yun eh. So, the general rule, the creditor cannot be compelled partially to receive the prestations in which the obligation consists. Exceptions to general rule, partial performance may be either requested or insisted in the following cases. Stipulation that is in part liquidated and in part unliquidated. What do you mean by that? Liquidated para determined na or determinable. Where the different prestations in which the obligation consists are subject to different terms or conditions, which affect some of them. When the parties know that the obligation reasonably cannot be expected to be performed completely at one time, and when there is abuse of right or if good faith requires acceptance. Article 1249. Okay? Ang sinasabi lang dito, class, kailangan yung payment of debts in money, ang ibabayad dyan kung ano ang pinag-usapang currency. However, kapag may impossibility to deliver such currency, ang default ay legal tender in the Philippines. Okay? Delivery of promissory notes payable to order or bills of exchange or other mercantile documents, checks, etc., promissory notes, it shall only produce the effect of payment only, one, when they have been cashed, or two, when through the fault of the creditor they have been impaired. So RA 8183, before kasi kailangan ang currency, ang gagamitin currency ay Philippine peso. Pero ngayon, kahit na ano na. Kung anong pag-usapan nila. So kahit na pounds, dollars, etc. What is legal tender? The currency which a debtor can legally compel a creditor to accept in payment of a debt in money when tendered by the debtor in the right amount. So question, 1 million pesos. Eh asar ka kasi sinisingil ka makulit, di ba? So aasarin kita. Babayaran kita ng tigpipisong 1 million, di ba? Tigpipiso. 1 million pesos, tigpipiso. Pwede ba 'yon? Well, kung gusto ni creditor tanggapin, hindi bahala siya. Pero hindi niya makocompel si creditor na tanggapin yun. O payment by means of instruments or credits. Okay? Again, kailangan ang ibabayad mo ay legal tender dito sa Philippines, di ba? Promissory notes, checks, etc. Other mercantile documents, instruments, they are not legal tender. Therefore, the creditor cannot be compelled to accept them. Okay? So, however, the creditor, kung gusto niya, pwede niya i-accept. Pwede niyang i-accept, pero yung acceptance na yun will not produce the effect of payment unless they have been cashed or impaired through the fault of the creditor. So, Roman Catholic Bishop of Malolos, Incorporated versus IAC. Ang issue lang dito about valid tender of payment, kung yung check ay valid tender of payment, at sabi ng Supreme Court, no. It is not a legal tender. So, i-discuss ng inyong kaklase yan. Article 1250. Ito ang i-discuss naman dito, extraordinary inflation or deflation. So, kailan nangyayari ito? Diba? May requisites yan. Number 1, there must be an official declaration from the BSP. Diba? Number 2, kailangan class contractual in nature yung source of obligation, contractual. Number 3, the parties expressly agreed to consider the effects of the extraordinary inflation or deflation. A contractual agreement is needed for the effects of extraordinary inflation to be taken into account to alter the value of currency. Ito naman yung place of payment. Place of payment. Doon? Saan ka dapat magbayad? Number 1, stipulation. Ayan, there being no express stipulation. Therefore, ang una dyan, kung ano pinag-usapan ninyo, what was agreed by the parties. Number 2, if there's no stipulation, kapag determinate thing, di ba, place where the thing might be located at the time the obligation was constituted. In any other case, it must be at the place of the domicile of the debtor. Okay, special forms of payment tayo. 4 yan discuss dyan sa subject matter natin. Dation in payment, application of payments, payment by cession, tender of payment, and consignation. So strictly speaking, application of payment is not a special form of payment. Ano ba ito dation and pago na to or dation in payment? Dation in payment is conveyance of ownership of a thing by the debtor to creditor as an accepted equivalent of performance of a monetary obligation. For example, class, si A may utang na 1 million pesos kay B. Nung sinisingil na siya ni B, walang pera si A. Baka hindi lang siya liquid. Ano ibig sabihin pag hindi siya liquid? Wala siyang cash. Maraming assets siya, marami siyang assets. Pero wala siyang cash kasi na-invest niya or puro properties, di ba? Etc. So, ang ginawa niya, marami naman ako sasakyan. So, sabi ni A, o B, babayaran ko na yung 1 million mo, pero pwedeng hindi pera kasi wala akong 1 million, wala akong cash. Mayroon lang ako sasakyan. So, binigay niya yung sasakyan kay B. Tinanggap ni B. That's dation and pago. Okay? Kasi nabayaran na yung na-extinguish na yung obligation. Dahil nga nagbigay na siya ng sasakyan. Di ba? And ano ito, shall be governed by the law of sales. Di ba parang sales kasi ang nangyari? Parang binili ni B yung sasakyan ni A for 1 million pesos. A debt in money is satisfied not by payment of money, but by the transmission of ownership of a thing by the debtor to the creditor. Okay, requisites of a valid dation in payment, performance of the prestation in lieu of payment. Yung nangyari kanina, di ba? Nagbigay siya ng sasakyan. There must be some difference between the prestation due and that which is given in substitution. Sa example kanina, 1 million pesos versus the car. There must be an agreement between the creditor and debtor. Diba? So, ibig sabihin, kailangan ng consent ni creditor and the debtor. And ang result ng pagbibigay ng sasakyan ni A kay B ay extinguishment of the obligation. Ano pagkakaiba naman ng sale at saka dation in payment? Sa sale, no pre-existing credit. Sa dation, meron. The sale obligation is created. Sa dation, extinguishment of obligational purpose. Sa sale, the cost is the price paid from the viewpoint of the seller or the acquisition of the thing sold from the viewpoint of the buyer. Dito sa dation in payment, since ang purpose ito is to extinguish an obligation, from the viewpoint of the debtor, gusto niya ma-extinguish ang obligation. At yung sa viewpoint naman ng creditor, it is the acquisition of the car in our example. The party sa sale, the parties deliver and receive the thing, a seller and buyer. Dito sa dation in payment, the parties deliver and receive the thing as debtor and creditor. Diba? Sa sale, there is more freedom in fixing the price. Sa dation in payment, well, ayun na. Kung ano na pagkasunduan nila, di ba? Okay. Application of payment. Application of payment, nangyayari naman niya. Si isang tao, si A at saka si B, di ba? Si A, marami siyang utang kay B. For example, 1,000 pesos, 5,000 pesos, 10,000 pesos, 100,000 pesos. Sa iisang tao lang siya umutang noon. Yun, application of payment. Paano nagkakaroon ng application of payment, di ba? For example, ang pera lang ni B ay ang may utang si A kay B, di ba? Ang pera lang ni A para pambayad ay 20,000 pesos. Kaya ang dami niyang utang kay B. Paano niya i-apply yung 20,000 pesos dun sa apat na utang? Yun ang application of payments. So application of payments are designation of the debt to which should be applied the payment made by a debtor who has various debts of the same kind in favor of one and the same creditor. So 1:1. Requisites. So one debtor, one creditor. 2 or more debts. Diba? Sabi nga natin sa example natin, 4. The debts must be of the same kind. Pare-parehong sum of money. The debts to which payment made by the debtor has been applied must be due. Kailangan due yung 4 na utang. And the payment made must not be sufficient to cover all the debts. Doon sa example natin, 20,000 lang ang pera niya. Ang utang niya, 1,000, 5,000, 10,000, 50,000. So, hindi sapat na kanyang pera. Ano ang rules dito? Okay? Generally class, the debtor has the choice. So, must indicate choice at the time of the making a payment. The choice is irrevocable unless creditor consents to the change. Kapag hindi nag-apply ng payment si debtor, si creditor may right. Paano niya i-exercise yung right na yan? By specifying in the receipt which debt is being paid. Kapag naman hindi rin nag-apply ng payment si creditor, or if the application is not valid, the debt which is most onerous to the debtor among those due shall be deemed to have been satisfied. Ano ibig sabihin natin na most onerous? Ito yung mas burdensome. For example, 1,000 pesos and 1,000 pesos with interest. Interest bearing. Mas onerous to. Kasi ito lumalaki eh. Itong isa hindi lumalaki. Diba? So, ayun, burdensome. Pero class, dito sa application of payment, there is no hard and fast rule. kung ano yung onerous. Depende yan sa sitwasyon. Case-to-case basis. If the debts due are of the same nature and burden, the payment shall be applied to all of them proportionately. If neither party has exercised its option and there is disagreement as to debts to which payment must be applied, it is the courts who will apply the payment according to justice and equity of the case. Article 12253. Sinasabi lang naman dito na kapag interest bearing ang isang debt, yung payment sa interest muna bago yung principal. Article 1253 is mandatory. Okay? However, it is dependent, well, subject to stipulations, di ba? Tsaka waiver by the creditor. So the creditor can refuse an application of the debtor made contrary to the provision of Article 1253. Paano natin i-ano to? At ito yung most onerous. Okay? Paano masabing most onerous nga? When it is more burdensome. So no fixed rule was laid about this. So it's a case-to-case basis. So ano yung mga Supreme Court rulings? Okay, an interest-bearing debt is more onerous than a non-interest-bearing debt, even if the latter is an older one. Obvious naman, di ba? Kasi yung isa lumalaki. Lumalaki yung utang mo. Yung isa wala. A debt as a sole debtor is more onerous than as a solidary debtor. Sa sole debtor, syempre, sarili mo lang yun. Wala kang katulong. Solidary debtor, may mga kasama ka dyan. Di ba? All things being equal, older debts are more onerous. Debts secured by a mortgage or by pledge are more onerous than unsecured debts. Common sense ito. Siyempre, di ba, may pwedeng mawalang property, di ba? Of two interest-bearing debts, the one with a higher rate is more onerous, di ba? Pero class, case-to-case basis to, ha? For example, 5,000 pesos with 10% interest versus 100,000 pesos with 3% interest. 7% interest. Mas maliit yung 7, pero kung kwentahin mo, mas malaki yung magiging interest ng 100,000. So, depende yan. An obligation with a penalty clause is more burdensome than one without penalty clause. Ano yan? Self-explanatory. In a case, the unpaid rentals due from the purchase of property occupied by him were held more onerous than the balance of the price of the property, the provisional sale of which was canceled by the seller for non-payment of the installments. Okay, dumako naman tayo sa payment by session. Payment by session, one debtor, maraming creditors. Tapos ito si debtor, wala na siyang pambayad sa kanyang creditors. Yun. So, sinasabi dito, yung session, assignment or abandonment of all the properties, meaning lahat of the debtor for the benefit of his creditors, in order that the latter may sell the same and apply the proceeds thereof to the satisfaction of their debts. Okay? Of the satisfaction of their credits. So, si debtor na nag-iisa, i-abandon niya lahat ng kanyang property para sa kanyang creditors. Ano yung requirements? 2 or more creditors, di ba? The debtor must be partially or insolvent. Must be insolvent, whether partially or not. The assignment must involve all the properties of the debtor. The session must be accepted by the creditors, meaning the creditor's consent is necessary. Unless there is a stipulation to the contrary, the assignment does not make the creditors the owners of the property of the debtor. And the debtor is released from his obligation only up to the net proceeds of the sale of the property assigned. For example, ang value ng utang niya doon sa 4 na debtor na creditors ay 100 million pesos. Naibenta lang niya yung property niya na 50 million pesos. Therefore, binatita na pang 50 million pesos. So, ano pagkakaiba ng payment by session sa DATION? Payment by session, maraming creditors. Sila kayo maghahati-hati doon sa proceeds ng sale ng properties ni debtor. Ano naman yung DATION? One creditor lang. Session, in session, the debtor is insolvent at the time of assignment. Sa DATION, hindi kailangan yun. Hindi kailangan yung insolvency. Session, it involves all properties of the debtor. Diba? Sa DATION, hindi. Kung ano lang, particular property. Session, the creditors only acquire the right to sell the thing and apply the proceeds to their credits pro rata. Sa DATION in payment, the creditor becomes the owner of the thing given by the debtor. So, ang DATION kasi is an act of novation. Pag-aaralan natin yung novation. Medyo latter part ng ating discussion. Ano naman yung tender of payment and consignation? Okay, class. Tender of payment is the act of offering the payment. As a general rule, class, tender of payment is necessary. Ano ang exceptions to that rule? Itong 5 na to. Yan yun. Yan yung mga instances na hindi na kailangan ng tender of payment. Okay? So, ano yung mga exemptions na yun? Ano naman to eh? Self-explanatory, di ba? Absent or unknown yung creditor. Saan ka mag-offer ng payment? Incapacitated. So, bakit ka mag-offer ng payment? Without just cause, the creditor refuses to give a receipt. Bakit mo ipipilit? Di ba? 2 or more persons claim the same right to collect. Kanino ka magbibigay ng payment ngayon? When the title of the obligation has been lost. So, pwedeng iba na ang may-ari. Di ba? So, magkakamali ka pa. So, as a general rule, tender of payment is necessary. Exceptions, yung 5 na yan. Class, you have to remember, tender of payment is necessarily extrajudicial, meaning out of court. And consignation is necessarily judicial. So, ayan ibig sabihin ng tender of payment. So, tender of payment, the act of offering, di ba? It is an act preparatory to consignation, which is the principle and from which are derived the immediate consequences which a debtor desires or seeks to obtain. Ano naman yung consignation? It is delivery to the court, di ba? Depositing the thing or amount due with the proper court. Kapag inayawan ni creditor, without any just cause, di ba? Or yung 5 instances na yun. Ano yung sabihin na, bakit? Bakit tayo may consignation? Kasi class, kapag ayaw tanggapin ni creditor yung bayad mo, di mayroon pang risk sa iyo yun, di ba? Paano kapag interest bearing siya, di ba? Lalaki yung liability mo. Di ba? So, kaya merong remedy of consignation. Ano requisites of a valid tender of payment? Of course, tender of payment must comply with the rules of payment. It should be in legal tender. It should be unconditional and for the whole amount. Remember, class, partial payment is no payment at all, and it must be actually made. A tender, even if valid, does not by itself produce legal payment unless it is completed by consignation. It has the effect, however, of exempting a debtor from liability for interest. Requisites of a valid consignation. Of course, kailangan may valid debt which is due. Number 2, tender of payment by the debtor and refusal without justifiable reason by the creditor to accept it, or pumasok dun sa exceptions. Number 3, notice. Bakit kailangan mo mag-notice dun sa persons interested in the fulfillment of the obligation? Para bigyan sila ng chance para kunin na agad yung prestation. Diba? Yung amount due. Kasi kapag tumatagal yan sa court, May additional charges. Number 4, consignation of the thing or sum due. Okay. Number 3, previous notice of consignation. Ibig sabihin pala, hindi mo pala ibibigay sa court. Para pinabibigyan mo sila ng chance na, ilalagay ko na to sa court. Kunin nyo na habang hindi ko pa nalalagay sa court. Ganun yun. Number 4, consignation of the thing due. I-deliver mo na sa court, deposit sa court. And number 5, mag-notice ka ulit. Paano mo na ino-notice? Bakit ka mag-notice? Kasi class, kapag nasa court na at tumatagal yan, may mga additional charges yan. Diba? So, mababawasan yung pera ni creditor. So, you are giving him the chance para kunin na agad sa court yung pera or yung property. The absence of any of the requisites is enough ground to render consignation ineffective. Article 1257. Ito yung sinasabi ko, purpose of the notice. It is to give the creditor a chance to reflect on his previous refusal to accept payment. Diba? Kasi nga, magkakaroon siya ng additional charges sa court. So, ano yung requirement versus spousal subordo? Tiyatanong lang dyan, whether or not the consignation was valid. Sabi ng Supreme Court, no. Kasi nga, kailangan yung notice. Diba? Previous notice. Article 1258. The purpose of the second notice, yung sinasabi ko kanina, after the consignation na yan, is to enable the creditor to withdraw the thing. Diba? Para bigyan mo ulit siya ng chance. Nasa court na. Pag tumagal yan, mababawasan pa yung pera mo. Magbabayad ka. Kunin mo na. Article 1259. Yung charges niyan, yung consignation, will be against the creditor. Bakit? Kasi siya yung umayaw. Siya yung nag-refuse without any justifiable cause. However, if the consignation is improperly made, it will be the debtor who will shoulder the expenses of consignation. Article 1260, where all the requisites for a valid consignation have been complied with, the loss of the thing or amount consigned occurring without the fault of the debtor, before the acceptance of the consignation by the creditor or its approval by the court is for the account of the creditor. Kasi nga, kasalanan ni creditor kung bakit nasa court kayo yung pera o yung property. Kung tinanggap naman niya kasi yon, walang problema. Okay, ano naman yung effect of withdrawal of the object of or amount deposited? Yung first part niyan, if before the creditor has accepted, withdrawal by the debtor is a matter of right because he is still the owner of the thing or amount. However, kapag with the consent of the creditor loses every preference which he may have over the thing. Second, solidary co-debtor, guarantors, and sureties are released. However, class, yung solidary debtors, they are only released only from their solidary liability. Pero hindi doon sa shares nila. Diba? And the obligation is revived. So, ganun na mangyayari. Okay? Let's now proceed to the loss of the thing due. Article 1262. Kailan natin masasabi na nawawala ang isang bagay? When it perishes, goes out of commerce, disappears in such a way that its existence is unknown or it cannot be recovered. In this section, loss of the thing due refers to both obligations to give and obligations to do. Okay? Requisites in order that an obligation to give may be extinguished by the loss of the thing. Number 1, obligation is to deliver a specific or determinate thing. Kasi sabi nga natin, di ba? A generic object does not perish. A genus non quam perit. The loss of that thing occurs without the fault of the debtor, and the debtor is not guilty of delay. Kaya naman hindi ma-extinguish yung obligation even though nawawala yung thing. When the law so provides, when the stipulation so provides, when the nature of the obligation requires the assumption of risk, and when the obligation to deliver a specific thing arises from a crime. Saan yan, di ba? Saan nyo nabasa yung first three? Yan yung sa 4327. So ito yung sabi lang natin, Article 1263, generic thing never perishes. 1264, partial loss when only a portion of a thing is lost or destroyed or when it suffers depreciation or deterioration. Partial loss is the equivalent of difficulty of performance in obligations to do. Class, it is the courts who shall determine, under the circumstances, whether the partial loss of the object is equivalent to extinguishing an obligation. Article 1265, sinasabi lang naman dito na it is a disputable presumption, disputable presumption, na kapag yung bagay ay nawala in the possession of the debtor, the loss was due to his fault. Disputable yan kasi if there's a proof to the contrary, therefore, yun mag-shift yung presumption. However, this presumption does not apply in case of earthquake, flood, storm, or other natural calamity. 1266, physical impossibility, legal impossibility. Alam na natin yan, di ba? Discuss natin yan. Natural impossibility consisted of nature of the thing to be done and not in the inability of the party to do so. It appears that the thing to be done cannot by any means be accomplished. It renders the contract void. Kapag impossibility, in fact, out of the power of the obligor, it does not render the contract void. 1267. It authorizes total or partial release from an obligation. Kapag daw when the service has become so difficult as to be manifestly beyond the contemplation of the parties, pwedeng ma-release si obligor. Ang pinag-uusapan dyan, release, release. Hindi modification or revision. Kasi class, the courts may release an obligor from the obligation kapag sobrang hirap na. Hindi na talaga, at wala siyang fault, di ba? However, the courts have no power to modify or revise the contract. Oxena versus Jobson, case number 92. Kaya tanong dito kung pwede ma-release yung respondent. The answer is no. Kasi ang hinihingi niya ay modification. Hindi naman total or partial release. I-discuss yan ang inyong kaklase. Article 1268, ito yung sinasabi natin kanina na when the death of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price kahit na ano pang cause, kahit fortuitous event by his fault. Exemption. Kapag in-offer sa person na dapat natatanggap nito, yung taong yon nag-refuse without any justifiable reason. Article 1269. The creditor is given the right to proceed against a third person responsible for the loss without a need for an assignment by the debtor. Self-explanatory. The rights of action of the debtor are transferred to the creditor from the moment the obligation is extinguished by operation of law to protect the interest of the latter by reason of the loss. This is self-explanatory. Condonation or remission of debt, ito naman yung quits. Para tong donation. Diba? Parang, sige, hindi wala kang pera. Sige, wag na kang bayaran. Ganun yun. So, what is condonation or remission? It is gratuitous renunciation by the creditor of his right against the debtor. Waiver of rights to. Diba? Resulting in the extinguishment of the latter's obligation in its entirety or in that part of the same to which the renunciation refers. So, sa salitang kalye, ito yung quits. Sige, quits na tayo. Huwag mo nang bayaran. Ito yung requisites. It must be gratuitous. Kailangan walang Walang compensation. It must be accepted by the obligor. Kailangan may acceptance, may consent ni obligor, may acceptance. Kasi, sabi nga natin kanina, no one is compelled to accept the generosity of others. The parties must have the capacity. It must not be inefficacious. Ano yung sabihin inefficacious? Ito yung sobra. For example, ang pwede mo lang ibigay sa iba because sa wills and succession class, kailangan may matitira para sa heirs mo. Hindi pwede ma-prejudice sa kanilang rights. So, hindi ka pwede magbigay na makaka-apekto sa kanilang rights. Kasi kapag yun ang donate mo, that's inefficacious. And if made expressly, it must comply with the forms of donation. Remission being an act of liberality should be proved by clearer and more convincing evidence than what is required to establish payment. So, ano naman ito? Siyempre, ang papatunayan mo yun, ikaw si obligor. Gusto mong patunayan na extinguish na obligation. Mas madaling patunayan na nagbayad ka kasi papakita mo lang yung resibo, di ba? Kaysa sa kinwits. So, kailangan mong magpakita ka ng proof na talagang remitted na ang debt. So, ito yung second. Ito yung mga inofficious. So, the court may reduce the donation or the amount condoned accordingly. Ito Article 1271. The delivery of a private document evidencing a credit made voluntarily by the creditor to the debtor implies the renunciation of the action which the former had against the latter. So kapag daw dideliver ni creditor yung private document evidencing a credit to the debtor, ibig sabihin nun, it is presumed na may renunciation. Okay? Ano kailangan para i-nullify yung waiver? It should be claimed to be inofficious. So, kailangan patunayan ng debtor yun or no heirs. Article 1272. Kapag daw yung private document ay nasa possession ni debtor, disputable presumption ito ha. Disputable presumption again. Bakit disputable siya? Because if there is evidence to the contrary, mag-shift yung presumption. Mawawala yung presumption. So, it shall be presumed that the creditor delivered it voluntarily. So, anong essence? Ano naman kung nasa akin ngayon, kung deliver voluntary, kung ang presumption is delivered voluntarily yon ni creditor kay debtor. Kasi nga class, yun yung ang presumption naman nun, ang implication naman nun kapag nasa possession ni debtor yung private instrument evidencing the debt, it will be presumed that there was payment. Ngayon, kapag dahil nga mas madaling patunayan yung payment, kailangan patunayan mo rin yung remission or condonation. So, it is believed that the presumption of voluntary delivery should give rise to the presumption of payment. And only when it is known that indeed there is no payment should there be a presumption of remission. So, parang sinasabi doon na kapag nasa akin na yung evidence of, yung private document evidencing a debt, ang presumption is, nagbayad na ako. Ngayon, kapag naging issue kung nagbayad na ako o hindi, ang presumption nun is may remission unless proven otherwise. 1273, accessory follows the principal. So kapag ni-remit yung principal debt, extinguish na rin yung accessory. Diba? Yung accessory obligations. Pero kapag ang ni-remit ay accessory obligations, magsasubsist si principal obligation. Okay? Dito naman sa Article 1274, only the accessory obligation of pledge is presumed remitted, not the obligation itself. Kasi yung Article 1274, ang pinag-uusapan dyan yung pledge. The thing pledged. Ang confusion or merger of rights naman, ito naman yung meeting in one person of the qualities of creditor and debtor with respect to the same obligation. So, isang tao lang ito. Okay? Yung isang tao, nag-meet sa kanya yung personality ng debtor and creditor. Nangyayari ito kapag pasahan yung utang. So si A, for example, promissory note. Si A, pinasa niya yung promissory note kay B, si B kay C, si C kay A. Kaduluduluhan, si A ay creditor at debtor ng sarili niya. Dapat ba niya singilin yung sarili niya? Kalokohan yun. Diba? Baliw na siya kung gano'n. Requisites, it must take place between the principal, debtor, and creditor, and it must be complete and definite. Article 1276, the extinguishment of the accessory obligation does not carry with it that of the principal obligation. So consequently, merger which takes place in the person of the guarantor while it extinguishes the guarantee leaves the principal obligation in force. This is self-explanatory. Diba? Accessory follows the principal and not the other way around. Each debtor has his own creditor to whom he is liable, and confusion taking place in the person of any debtor or creditor does not affect the others. Thus, the confusion will extinguish only the share corresponding to the creditor or debtor in whom the two characters concur. Ito yung sa joint yan, ha? Kapag naman daw nangyari yung merger sa solidary debtors, it will extinguish the entire obligation. Bakit? Kasi solidary yan eh. Isa lang yan, di ba? Considered as one obligation. Ang compensation naman class, it is the extinguishment to the concurrent amount of the debts of two persons who in their own right are reciprocally principal debtors and creditors of each other. Ang nangyayari naman dyan, class, as against confusion, dito sa compensation, dalawa naman siya. Si A and B, si creditor, si debtor. Ang nangyari doon, si creditor, naging debtor din naman siya dito ni debtor niya. So, di ba? So, sila ay may utang sa bawat isa. Ganun lang yon, compensation. So, sa case number 94, PNB versus Song Acero, tinatanong lang dyan kung may compensation. Ang sabi ng Supreme Court, wala. Kasi hindi sila, there's insufficient evidence that PNB is a creditor of Isabela. O, ito yung sabi natin na, di ba? Sa compensation, dalawang taong involved. Sa confusion, isa lang. Doon nag-meet ang pagiging debtor and creditor niya. Di ba? Sa compensation, 2 obligations. Sa confusion, 1 obligation. Compensation, indirect payment. Kasi nga, dito sa compensation class, kahit na hindi alam ng mga parties, kapag nagkaroon ng legal compensation, automatic yon. Dito sa confusion, impossibility of payment. Bakit? Dahil hindi mo pwedeng bayaran ang iyong sarili. Okay, compensation, difference between compensation and payment. Compensation takes effect by operation of law, meaning kahit na hindi alam ng parties, nangyayari yung compensation. Automatic. Payment takes effect by act of the parties. Kailangan may isang kikilos, di ba? Kadalasan yan, debtor. It is not required that the parties have the capacity to give or to receive in compensation dahil nga, automatic ito by operation of law. So kahit na hindi nila alam, kahit na hindi sila capable to receive payment, to receive or to make payment, ano yan, hindi mahalaga yon sa compensation, yung capacity. Sa payment naman, katulad na sabi natin kanina, must have free disposal of the thing due and capacity to alienate it. And in compensation, the law permits partial extinguishment of the obligation. Sa payment, kailangan complete and indivisible. That's a general rule in payment. Kasi pwedeng hindi complete kapag, of course, pumayag yung creditor, may stipulation, etc. Article 1279. In order that compensation may be proper, it is necessary. Ano ang mga requisites ng compensation? Parties are principally bound as creditors and debtors of each other. Number 2, both the debts consist in the sum of money or of consumable of the same kind and quality. Number 3, the two debts must be due or demandable. Number 4, the two debts are liquidated. And number 5, no retention or controversy commenced by a third person. Sa Francia versus IAC case number 5, iyatanong dito, can taxes be legally offset? The Supreme Court ruled that no. Kasi ang taxes ay yung taxes na kinukuha ng government and the taxpayers, they are not mutually creditor and debtor of each other. And also the lifeblood theory in tax. So, i-discuss ng inyong classmate yan. CC versus CA, case number 98. Tanong din dito, pwede ba yung compensation sa case na to? Sabi ng Supreme Court, no. Because Lapus is only an agent of Albert Smith and or Dr. Deal. So, kailangan, kung agent lang siya, hindi siya yung principal debtor or creditor. Article 1280. The guarantor may set up compensation as regards what the creditor may owe the principal debtor. This is an exception to the general rule that only the principal debtor can set up against his creditor what the latter owes him. Bakit pinapayagan yung guarantor? Kasi interested siya na ma-extinguish yung obligation. So kahit na subsidiary liable lang siya, binibigyan siya ng right to set up compensation. 1281, pwede raw yung compensation be total or partial. Kapag two debts equal, total compensation yon. So sa example natin, si A may utang kay B na 100 pesos. Si B may utang kay A na 170. So mag-offset sa 100 kasi 100 lang yung utang ni A kay B. So may matitirang 70 na utang si B kay A. Okay? Partial compensation yon. Ginangyayari yan sa totoong buhay, di ba? Kaya medyo maiintindihan nyo yan agad. Article 1282. Di ba? As a general rule, kailangan due yung debts. Pero the parties are free to agree on the compensation of debts which are not yet due. 1283, ito madali, ano lang naman to eh. It's claim for damages. So, unang-unang dapat gawin dyan, kailangan i-prove na may claim sila. Diba? Kasi kung hindi nila ma-prove na may claim sila, bakit magkakaroon ng offsetting? So, the right to offset may exist, but the question of how much is to be offset is factual in nature. Ito, Article 1284, resistible and voidable contracts or obligations. Mapag-aaralan natin ito in the latter part of the SEM. They are valid until they are rescinded or avoided or annulled. So bago magkaroon ng judicial declaration na rescissible or voidable yung isang contract or obligation, it is deemed valid. Therefore, kapag nangyari yung compensation bago yung judicial declaration, then they are valid. Valid compensation yun. Article 1285 talks about effects of assignment of rights. So first paragraph, with the consent of the debtor, kailangan nag-consent si debtor. Debtor cannot set up compensation unless he reserved his right to compensation. Second paragraph, with knowledge but without consent of debtor, si debtor daw may set up compensation prior to the assignment, before the assignment, but not to the subsequent ones. Diba that? Yung third paragraph, kapag daw without knowledge of the debtor, meaning automatic, wala siyang consent, wala nga siyang knowledge. The debtor may set up compensation of all credits which he may have against the assignor and which may have become demandable before he was informed of the assignment. So ano to? Bakit may mga ganitong para sa itong Article 1285? Article 1285 kasi pwedeng si creditor, inassign niya yung rights niya sa ibang tao. So paano si debtor? Kung si debtor, may pwede siyang i-offset kay creditor, si creditor nag-assign na ng rights. Yan ang rules. Kung may consent, kung against the will, or without knowledge, etc. Article 1286, sinasabi ko nga sa inyo, compensation takes effect by operation of law, meaning automatic. Kahit na hindi alam ng parties na may compensation, kahit na nasa ibang lupalo pa sila ng daigdig, di ba? Pero yung indemnity for expenses of exchange or transportation to the place of payment shall be borne by the one who sets up compensation. Article 1287, sinasabi lang dito, hindi proper ang compensation kapag one of the debts arises from a depositum, obligations of a depositary, or bailee incommodatum. Also sa support. 1288, hindi rin po pwedeng compensation kapag it arises from civil liability arising from a penal offense. Bakit? Kasi sa depositum, diba? This contract is based on trust and confidence. This is fiduciary relationship. So, hindi mo pwedeng i-compensate yung bagay na pinagkatiwala sa iyo, di ba? Commodatum, parang ganyan din, same principle yan, di ba? Pinahiram ka ng isang gamit tapos i-set up mo for compensation, hindi po pwede. Support, alam naman natin yan, di ba? It's for sustenance, di ba? Where one of the debts consists in civil liability arising from a penal offense, that's a general rule. Pero yung offended party may claim the right of compensation. If a person should have against him several debts which are susceptible of compensation, the rules of the application of payment shall apply to the order of the compensation. Ito, yung rules of application of payment, diniscuss na natin ito. 1290. Sinasabi lang dito na automatic by operation of law. Kahit na hindi alam ng parties, mangyayari ang compensation when all the necessary requisites concur. So kahit na tutulog sila, nagkangyari ang compensation. Let's move to the last topic. Extinguishment of obligation, which is novation. What is novation? Novation, it is the total or partial extinction of an obligation through the creation of a new one which substitutes it. Nang nawawala yung original, may dumarating na iba. Diba? So, unlike other modes of extinction of obligation, novation is a juridical act with a dual function: to extinguish the original obligation, to modify an existing obligation, and to substitute a new one. Kailan nangyayari ang novation? Itong tatlo na to. Changing their object or principal conditions, substituting the person of the debtor, subrogating a third person in the rights of the creditor. Ano ang kinds of novation? May legal, operation of law, conventional, by agreement of the parties. According to how it is constituted, expressed, when it is so declared in an unequivocal terms. Ibig sabihin, malinaw na malinaw, gusto nilang mag-novate. Implied, when the old and the new obligations are essentially incompatible with each other. Last, remember the word, essentially. Ibig sabihin, kailangan talaga incompatible sila. According to extent or effect, it may be total or extinctive. Nawala talaga yung original obligation. Partial or modificatory. Na-modify lang. Diba? According to the subject, real or objective, kapag yung object or cause or principal conditions of the obligations are changed. Personal or subjective, person of the debtor is substituted or when a third person is subrogated to the rights of the creditor. Balik tayo sa Article 1291. Yung first is real or objective. Yung 2 and 3, personal yan. Okay? Mixed, alam na natin yan. So, object or principal condition of the obligation and the debtor or the creditor or both the parties are changed. Combination of real and personal. Article 1292. Ano naman sinasabi nito? Kailangan daw maliwanag na talagang incompatible yung original sa new obligation. Hindi mo pwedeng, hindi natin pinipresume ang novation. Iniiwasan nga natin ang novation. However, kapag they are essentially contradictory with each other, di ba? Essentially incompatible with each other, nangyayari ang novation. Requisites of a valid novation, the existence of a previous valid obligation, the original, intention or agreement and capacity of the parties to extinguish or modify the obligation, extinguishment or modification of the obligation. So yung original na modify, creation or birth of a valid new obligation. Effect of modifications of original obligation, kapag slight lang, original contract continues in force, except as to the altered terms and conditions of the obligation. Kapag naman material deviation or changes, di ba? The original contract should be treated as abandoned at may bagong darating. Bagong nagawang contract or obligation. Sabi sa NPC versus Direct, case number 110, may novation ba? Walang novation. So, kailangan daw malinaw ng may gusto ng novation or incompatible, essentially incompatible with each other. FUA versus YAP. Tinatanong din dito, may innovation ba? Sabi, yes. May innovation dito. So, tingnan natin yung mga cases na to, didiscuss na ng klase ninyo kung ano ang nangyari dito sa case ni FUA at saka ni NTC versus Direct. 1293. Novation which consists in substituting a new debtor in the place of the original one may be made even without the knowledge or against the will of the latter. Sino tong si latter? Latter is the debtor, di ba? But not without the consent of the creditor. Meaning, kailangan lagi ang consent ni creditor. Pero pwedeng walang consent si debtor. So, anong mga kinds of personal novation? Merong substitution and subrogation. Substitution when the person of the debtor is substituted. Diba? So, doon na tayo sa person of the debtor is substituted. Ano ang kinds of substitution? Merong expropriation at merong delegasyon. Expropriation, the initiative came from a third person and without the knowledge or against the will of the original debtor. Diba? At si third person assumes the obligation of the original debtor with the consent of the creditor. Kailangan may consent si creditor. So, walang consent dito si debtor. So, yan. New debtor has right to beneficial reimbursement. Beneficial lang, Hindi ano yan. Iba yan sa subrogation. Delegation takes place when the creditor accepts a third person to take place of the debtor at the instance of the latter. Ibig sabihin, ang initiative ay nanggaling sa debtor. At lahat sila ay may consent. New debtor is entitled to reimbursement and subrogation. The subrogation naman, class, when a third person is subrogated in the rights of the creditor. Creditor naman yung piritan. So, substitution sa debtor, subrogation sa creditor. So, substitution may two kinds, expropriation, delegation. Expropriation, walang knowledge or against the will of the original debtor. Sa delegation, may agreement yung tatlong parties. 1294, it refers to expropriation, substitution without original debtor's consent. Didiscuss natin yan. 1295, delegasyon naman yan. Ano ang general rule? All debtor is not liable to the creditor in case of the insolvency of the new debtor. So, napakalinaw naman yan, di ba? So, all debtor, hindi na siya liable kung maging insolvent man si new debtor. Ano ang exceptions niyan? Kapag yung insolvency existing and of public knowledge at the time of the delegation, and second, the insolvency was already existing and known to the debtor at the time of the delegation. Kasi may fraud yun. 1296. O, ito na naman to. Accessory obligations follow the principal. Pero hindi ibig sabihin, it's not vice versa. So, dapat, kapag nagkaroon na extinguished by reason of novation ang principal obligation, sa accessory obligations, extinguished din. Not the other way around. Article 1297, void you if the new obligation is void, the original one shall subsist unless the parties intended that the former relation should be extinguished in any event. So kapag void new obligation, void new obligation, anong general rule? No novation if the new obligation is void. Therefore, the original one shall subsist for the reason that the second obligation being inexistent. Diba? Kasi nga void daw yung yung new obligation. So, dapat ang mangyayari ay mabubuhay ulit si original obligation. That's the general rule. Ano ang exception? Kapag gusto ng party na void man o hindi ang new obligation, extinguish si original obligation. Ganon. So, voidable new obligation, if the new obligation is only voidable, novation can take place. Bakit? Kasi the voidable obligation is valid until annulled. But the moment it is annulled, the novation must be considered as not having taken place. And the original one can be enforced unless the intention of the parties is otherwise. Diba? Simple-simple. 1298. Void old obligation. Kapag yung old obligation naman yung void, malamang nothing to novate. Kasi inexistent yun. Kapag yung old obligation naman ay voidable, pwede innovation. Kasi voidable obligations are valid until annulled. Therefore, the novation is valid until annulled. Article 1299. Ito, if the original obligations was subject to a suspensive or resolutory condition, yung new obligation na mag-arise because of the novation shall also be under the same condition or whether suspensive or resolutory, unless the parties intended otherwise. Okay? Article 1300. Ito naman yung subrogation. Subrogation of a third person in the rights of the creditor is either legal or conventional. The former is not presumed yung legal, except in cases expressly mentioned in this code. The latter must be clearly established in order that it will take effect. So yung conventional daw, kailangan clearly established. So ano yung subrogation? The substitution of one person in the place of another with reference to a lawful claim or right, so that he who is substituted succeeds to the right of the other in relation to a debt or claim, including its remedies and securities. So, kadalasan nangyari ito sa creditor. Subrogation, ilang beses natin din-discuss yan. Ano naman yung conventional? Conventional, third person requires the consent of the original parties and of the third person. So lahat ng tatlong yon nagbigay ng consent. Ano naman ang legal subrogation? Dito lang sa tatlong instances na ito, pinipresume yung legal obligation. Number 1, when a creditor pays another creditor who is preferred even without the debtor's knowledge. Number 2, when a third person not interested in the obligation pays without express or tacit approval of the debtor. Diba? Self-explanatory. Number 3, when even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays without prejudice to the effects of confusion as to the latter's share. Ano ang effect ng kinds of subrogation? Again, conventional and legal. Conventional, kailangan may consent ng lahat ng parties, debtor, old or original creditor, the new creditor. Legal, kahit na walang agreement. By operation of law. Kailan nangyayari yung legal? Dito sa tatlong to. Article 1 through 03. Subrogation transfers to the person subrogated the credit with all the rights thereto appertaining, either against a debtor or against a third person, be they guarantors or possessors of mortgages, subject to stipulation in a conventional subrogation. Diniscuss natin yan ilang beses, di ba? So, hindi lang right of reimbursement, all other rights. Article 1304. A creditor to whom partial payment has been made may exercise his right for the remainder, and he shall be preferred to the person who has been subrogated in his place in virtue of the partial payment of the same credit. So ito, inaano lang dito yung partial payment ng si creditor, ang nakuha lang niya ay partial payment. So pwede niyang i-exercise pa yung right para dun sa mga hindi nabayaran. And sinasabi lang dito sa Article 1304, he shall be preferred to the person who has been subrogated in his place in virtue of the partial payment of the same credit. So that's the end of the extinguishment of obligations. So thank you everyone and good day.